Sloppy, sloppy, sloppy. The Kennedy Center board can't get even open defiance of a court order right, having screwed up by considering not one but two resolutions to slap Donald Trump's name back onto the Kennedy Center. And what did they get for their trouble? A new emergency filing by Representative Joyce Beatty, who's on the board, the only one with a conscience, the only one who cares about her fiduciary duties of prudence and loyalty to the public. She's filed late last night an emergency motion for stay invited by Judge Chris Cooper. And they've come to court and said they're going to put their name back on the Kennedy Center again. They voted to put Donald Trump's name not once, but twice, in as big as letters as they possibly can, possibly even larger than JFK's name on the only living memorial to that fallen president. They're going to give him the honorific of, by the way, it's not known as the President JFK Center. It's known as the Kennedy Center. But it's going to be the Donald J. Trump restored and rehabilitated and renovated with a plaza named after him. Are you effing kidding me? We have a word for that in my business. It's called contumacious conduct. It's called contempt of court. There's a 96-page order of Judge Cooper that has been effectively affirmed on appeal, at least as to the stay issues. And they're just saying, oh, we don't care. We're going to put the name back on. And you know how they did it? You know, this is Michael Popok, by the way. You're on Legal AF on the MeidasTouch Network. Take a minute, hit the free subscribe button. So excited that I jumped the gun there. I've handled board meetings as a general counsel, as a lead counsel. Okay, I know how board meetings work. And I'll tell you how they don't work. They don't set up a board meeting agenda by telling the board the following: that they're going to be approving the June minutes, they're going to be electing officers, there's going to be a litigation update, I wonder what that was about, and buildings and ground presentation. But what really they are being asked to consider, and being asked as fiduciaries, and they all need training on what is a fiduciary as the Board of Trustees, is that they were considering putting Donald Trump's name back onto the facility again. Where is that on the board package? Where is the board package? Where is that on the agenda? No, they snaked it in. They snuck it in. I guess they planned on having Elliot Burke, whoever that is, the general counsel, under his executive session, do a litigation update. And during the litigation update, say, hey, we're changing the name of the building. Yeah, that's not how litigation executive sessions work, Mr. Burke. And this is what Representative Beatty in her litigation is going to get to the bottom of. The best way to find out what really went down in that meeting, which is the subject of this new emergency motion, is to do discovery. Let's get all the emails and text messages, WhatsApp and Signal messages among and between the board members and the non-board member executives that run the Kennedy Center. Let's find out who's talking to Donald Trump and why. Let's find out about the phone messages back and forth involving Donald Trump. Shall we? How about Howard Lutnick, the Commerce Secretary, and his wife, Allison Lutnick, who sits on the board? Let's find out if she was a conduit and he was a conduit for connectivity back to Donald Trump. I mean, we already know that Donald Trump was on the phone call on August 13th when they voted, like some sort of bizarre, obscene phone call or heavy breathing. Joyce Beatty, in a clip, in an interview, said exactly that. So let me read to you from the filing. So I thought something was up when I saw two board resolutions. I'm like, sorry? Fundamental Board Governance 101. You have one resolution that's signed. You might have drafts, but you don't submit to the court a resolution to rename the Kennedy Center after Donald Trump, and then a couple of days later say, oops, we have a different one. According to Joyce Beatty and this new filing, they didn't have a different one. They had two that they looked at, two that were up there. We don't know which one was passed. That's a big problem with board governance issues and undermines any resolution. And when I caught that, I said, oh, what are they trying to do? Putting his name even bigger up there than before. Here's what the Norm Eisen group who brought this case, here's what they say on page 1. It's deja vu all over again. By federal statute, the John F. Kennedy Center for the Performing Arts and site thereof is a living memorial to John Fitzgerald Kennedy. 2 months ago, this court issued a crystal clear decision. It was 96 pages. Congress gave the Kennedy Center its name, and only Congress can change it. The court made clear that Congress took pains to ensure that the Kennedy Center's public spaces honor Kennedy and Kennedy alone. By law, no other individual besides Kennedy may be memorialized on the front portico of the building, nor does the board have the power to designate new memorials in the public areas of the center without congressional approval. In an act of obvious petulance, defendants hung a tarp over the building's iconic lettering obscuring President Kennedy's name from the face of the institution. Now, in a new breathtaking act of defiance of Congress and of this court, defendants have voted to return President Trump's name to the Kennedy Center's facade. This time, Trump's name will appear on the building not once but twice. Sure, if you're going to violate the court order and be in contempt of court, do it twice. Underneath President Kennedy's name, it will say, restored and renovated by President Donald J. Trump and endowed by the Trump Kennedy Center Fund, which frankly should not even exist. And the new motion continues. The memorandum of law continues. Speaking for, I think, all Americans, enough is enough. Defendants' contemptuous behavior must stop. The court decided this issue on May 29th. Defendants do not like the law. They do not like this court's enforcement of the law, but they are not above the law, and they must comply. This latest move is a transparent effort to rename the center in President Trump's honor, and returning his name to the portico and grounds where this court held it does not belong. If permitted to proceed, defendants will openly flout the law, as they apparently did the first time, risk added damage to this historic facade. And they want a stay while the court gets its heart and mind and jurisprudence around this issue. Let me continue on page 5. Congress gave the Kennedy Center its name, and only Congress can change it. Congress likewise took pains to ensure that no other memorial-like dedication could grace the center's public spaces. This is from the statute. By affixing President Trump's name to the building's facade, defendants violate Congress's unequivocal mandate. Let me go to the competing resolutions. The ultimate, this is the Keystone Cops. They don't know what they're doing. Amateur hour on the board, okay? No surprise. I don't think many of them served on boards, or certainly were not trained on what their fiduciary duties are. Why are there competing resolutions, which is how boards act? This is what the footnote 2 says. On the eve of the deadline for the plaintiff to file this motion, defendants, the board, informed plaintiff that they had provided the court with the wrong version of the resolution. But at this juncture, plaintiff only knows that 2 versions of the resolution were shown by Zoom to the board. Both. One has this weirdo, like future current tense thing, like current and future contributions. No, that doesn't make it not a living memorial to Donald Trump. At this juncture, plaintiff objects to this 11th hour errata, which is an error sheet, and does not concede that the latter field resolution represents the operative one. It is possible that defendants are confused or mistaken about which version they passed, a fact that only underscores the shambolic nature of the proceedings on August 13th. In the end, none of this is material. Either version is unlawful. This appears, and then they point out in the red line this added new language of future tense, changing tenses of verbs from past to present. This appears to be an effort by defendants to suggest that their inscriptions and plaza designation do not memorialize President Trump because they are honoring current and future actions. If this is their theory, it is preposterous. The inscriptions are written in the past tense. Moreover, President Trump's current actions today become past actions tomorrow, meaning the inscriptions and plaza renaming honor past actions. Let me turn to page 11 of their filing, and then I'll tell you what's going to happen next in this case and what should happen next. The board's recognition resolution adding 2 new inscriptions onto the portico for Trump is an apparent effort to effectuate the renaming in another guise. If a patron attends the Kennedy Center, sees Donald Trump's name emblazoned on the portico, and learns about the President Donald J. Trump Plaza, it will appear that the institution is once again named for Donald Trump. On page 18, as they round out their briefing, The bizarre and rushed way in which the board adopted this new recognition resolution, keeping trustees in the dark until the last minute, neither circulating the resolution in advance nor including the measure on the agenda, was widely imprudent and constituted a breach of fiduciary duty. All right, let me touch on that for a moment, because I've been involved with board breaches before, both under Delaware law and under municipal law and corporate law. Here's what I think the judges should do. I think the judge should ultimately remove the board. Yeah, you heard me. They should remove the board for their constant breaches of fiduciary duty, duties of loyalty, duty of prudence that they have sworn to uphold to the public. It is a public trust. They have forfeited their right to continue to be board members of a public trust. They should be removed. The next motion that I think we should see from the plaintiffs is one to remove the board, put it into receivership, have a court-appointed officer of the court, maybe a former federal judge, run the administration of that Kennedy Center, advise the judge about whether it should be closed or renovated at all. And of course, make sure the name doesn't sneak back onto the building. That is the obvious next step in this case. You start with the stay to stop the naming. That you got to do. I understand the filing from that. You raise the issues. You conduct your discovery. I want depositions of all the board members. I want to see all the documents and paperwork leading into this meeting. I think they're being kind in the filing. It says they kept the board in the dark. I don't think the board was in the dark for August 13th. I think Joyce Beatty was kept intentionally in the dark. I think the others spoke to each other outside of the proper forum of a board meeting, which is inappropriate. And I think there's probably text messages and emails and correspondence and phone calls among and between the people on the board and Donald Trump. And all that should come out to the open. And that should allow the judge to use his equitable powers to preserve and protect that living institution, memorialization to John F. Kennedy, and protect the public trust. Remove the board. Let them fight to get back in. You know, and I'm dead serious about this. I've been involved with enough board removal issues and companies being put in receivership and having officers of the court who can be trusted report back. I mean, look, the Trump Organization, Donald Trump's private company, is under, for another 6 months, court-ordered monitor. You know, former federal judge Barbara Jones sits over the Trump Organization watching all of the money flow and transactions and reports back to a judge. Same thing here. Till my next report, good news programming note, I'm trying to get Norm Eisen, Democracy Defenders, who's one of the big lawyers here involved in this case on behalf of Representative Beatty, to join us on Legal AF. I think that's going to happen as early as next week. He also represents the defendant, Davey Hearn, in the reflecting pool and a number of other important mail-in balloting and voting cases. So I think you're really going to like the combination of Legal AF and Norm Eisen for next week. Until my next report, I'm Michael Popok. Hit the free subscribe button on Legal AF YouTube channel. Popok here. When life changes in an instant because of an injury or the bad acts of another, you need fighters in your corner. The Popok firm is dedicated to helping the injured and their families get justice and the money they deserve, and we don't back down. Contact us today and let's start your fight for justice together.